Hello, I'm Emma Patterson. I'm the Principal Solicitor at Patterson Law. We are national motoring solicitors and we cover the whole of England and Wales. We don't deal with matters in Scotland, but we cover the rest of the UK, and we have around 5 to 10 cases in courts around the country every day of the week. We deal with motoring offences. We do not specialise in any other area of law. There are 22 of us, and we devote the entirety of our time to defending motorists around the UK. The following is an outline of the statutory provisions in relation to a particular road traffic offence. If you have a specific question, then please call us on 01626 359 800 and we will be happy to go through the specifics of your case with you and to apply the legislation as appropriate. We hope that you find the video useful. The law is quite technical, so if you do want specific advice, we will always do a free advice call with you on 01626 359 800. Thank you. This is a chat about Section 143 of the Road Traffic Act. I'm the Principal Solicitor at Patterson Law and my name's Emma Patterson. The allegation is about using a motor vehicle without insurance, and it's not to be confused with a slightly different offence which is called keeping a vehicle without insurance. There are in place compulsory insurance rules now that mean that even if you're just the keeper of a vehicle and there's no insurance in place, you can be punished and you can get a fine. If you get this type of punishment and this type of fine for keeping a vehicle without insurance, it's financial. It carries the risk of either a fixed penalty from the DVLA or a fine at court and costs and prosecution costs, but it doesn't carry the risk of penalty points. So keeping a motor vehicle without insurance is a slightly different offence, and it basically means nobody's ever caught you either driving the vehicle or being in close proximity to the vehicle. Having said that, the offence of using a motor vehicle, which is what this section 143 is about, can be committed without you actually ever being seen driving the vehicle. So there's an important case that says having use of a vehicle can amount to using it even if the police don't actually ever see you driving the vehicle. So there's a fine line between the two, but basically having use of a vehicle can carry 6 to 8 penalty points and a hefty fine, and that's the offence that we're going to talk about now, which is using or having use of. There are other offences of causing or permitting somebody to drive without insurance, which I'll touch upon briefly towards the end. In essence, if you're going to drive a motor vehicle on a road or in a public place, here it is, then the vehicle must be insured. There must be in place insurance, or otherwise known as an indemnity, where if you have an accident, you are covered, you are underwritten by an insurance company who will pay out damages to the other party if it's determined that that accident was your fault. And here we have the issues over causing or permitting another person to drive a vehicle on a road without insurance, and again I'll talk to you about that in a minute. There's a statutory defence in relation to using a motor vehicle without insurance in section 143 subsection 3, and basically what it says is that if you can show that, and it means you have to prove it, because if you look at this section here it says you have to prove, so that means it's a statutory defence. That means the burden of proof reverses, so that you have to make the court sure, but not beyond reasonable doubt. You only have to make the court sure on the balance of probabilities, which means you have to make the court 51% or more sure that the vehicle didn't belong to you, was not in your possession under a contract of hire or loan, that you were using the vehicle in the course of your employment, and that you had no reason to believe that there was no insurance in place. So that's the defence that people use when they're driving in the course of their employment and they're using a works vehicle generally. That's normally the scenario. It's not necessarily restricted to that, and we've argued this statutory defence when people are driving in the course of their employment and using a partner's car. But talk to us about the specifics of it and we'll give you some in-depth advice. But there is a statutory defence. Now, no insurance law is really complicated because there's a huge overlap between contract law, which is a civil issue, and criminal law. And when you take out insurance with an insurance company, it's a contract. So you pay your money, and in return for that, you get a promise from the insurance company that if you have an accident, they will indemnify you. Now, quite often police officers, we seem to deal with this issue a good few times every week, which is where police officers will say to you that your insurance is void or invalidated. It will be to do with things like if you've got a problem with your license and perhaps it's been suspended for failing to surrender it for points to be endorsed. Perhaps you're a learner driver and you've driven without supervision and therefore you're driving not in accordance with your license. Perhaps the car itself isn't insured, and the police will often suggest that your insurance is void as a result of that. Now, the most important thing is that this is not normally the case. What the officers are purporting to do is to comment on a contractual relationship between you and the insurance company. There's a really important case called Adams and Dunn, and in Adams and Dunn, it was concluded that insurance cannot be voided with retrospective effect. So if your insurance on the face of it covered you to do what you were doing, then a police officer cannot say to you your insurance is void. The insurance company have to have made the decision to cancel your insurance. So for example, if you, even in cases where somebody obtains insurance by making a false representation, perhaps in relation to where they live and where the vehicle is stored, or perhaps in relation to their age because they're trying to get cheaper insurance, then obviously that's naughty and you can be convicted of making false representations to obtain insurance, which is a different offence. But technically speaking, that person will probably still have a defence in relation to the allegation of driving without insurance, because the insurance was valid at the time that they were driving. If the police officer makes a call to the insurance company and says, "Do you realise that Billy Bob is 18 and not 28?" then the insurance company can say, "No, we didn't realise that, we're cancelling the insurance," but that only has effect into the future. So 10 minutes previous to that, when Billy Bob was driving, and when the insurance company were oblivious to the problem, the insurance contract was probably valid. So it's really complicated, and police officers often make mistakes, and we have an extraordinarily high success rate at contradicting police officers' suggestions that insurance is void. It really is about whether or not the contract was fundamentally void because it just didn't cover you to do what you were doing, or whether the insurance company had already cancelled it. Insurance cannot be cancelled with retrospective effect. It can only be cancelled into the future. And that's the main area of advice that we seem to give when we're talking to people where it's suggested that their insurance wasn't in place. In no insurance cases, if you had an honest and reasonable belief that you were covered, and it's a case called Renison and Nola, it's a very old case, but we're using it a good few times every week in courts all around the UK. If you can show, in accordance with the case of Renison and Nola, that you had an honest and reasonable belief that you were covered, so your insurance was cancelled without your knowledge, and you had an honest belief that you were still covered, then you can avoid the penalty points. That's called a special reasons argument. It still involves going to court, giving evidence on oath, and persuading the magistrates that you had an honest and reasonable belief that you were covered. And if they agree and they believe you, then they have a discretion to find special reasons, which means they won't endorse the points. And often they'll give an absolute discharge as well. We tend to argue special reasons in no insurance cases, especially when we're dealing with named drivers who didn't realise that the insurance policy had been cancelled. They weren't responsible for the direct debits, and they hadn't been told by the policyholder that there was a problem. So quite often we'll argue special reasons in those cases. It's a complicated area of law. I hope you can see that from this initial description, but it's an area of law where we are often able to help people either undermine an officer's suggestion that the insurance was void, or argue special reasons to persuade the court not to endorse the points because the person involved had an honest and reasonable belief that they were covered. If you want to talk to us, please give us a call, 01626 359 800. We will assess the specifics of your case and give you appropriate advice on the best way forward. But don't just take it on the chin. Too many people accept fixed penalties for no insurance when in fact they had a defence or at least a strong special reasons argument. Thank you.